Okay. So, at the break, some people asked me some questions, but let me tell you what one fellow asked. He wants to know about my greatest failure.
Got a few hours?
So, anytime you don't achieve the result you want, it's disappointing, right? But you can never, who's asking, you were asking me, you can never guarantee the result to your client. Never. I mean, I don't know how it is here in the United States. I don't care if you have the law, if you have the regulations, if you have precedents, if you have the greatest client. You've got Brad Pitt to put on the witness stand for your client. I think he's popular here, yes? No?
Yes.
Do you know who he is? Yeah. Okay, I don't know, so I'm trying to think of movie star. You've got the great, you just can't guarantee. You can't, because you don't know, you just don't know how the judge is going to rule, and they have complete discretion. Calandra, let me tell you about this case. Now, I already told you, I lost this case, so you know the answer already. Let me tell you what the issue was. The United States Tax Court, the government sends a notice of deficiency. It's a special letter. And when you get that letter, it says you owe this much money. You have 90 days, 90, to, hey Vince, can I have my check? Yeah. I gotta ask.
Here, let me take it. This is a full service now. The bulls.
Okay, you've got 90 days to make a decision. Go to the United States Tax Court or pay. Some people don't have the money, that's a different issue, but that's your decision. If you pay, you can then think about going for a claim for refund and going to the district court. Can you put that schematic back? But you have, in the 90 days is very, very serious. Because if you miss the 90 days, you cannot go to the United States Tax Court. You're out. Hard line. No exceptions. No exceptions. When I was in high school, I played American football. You know American football, right? Okay. And my coach said, there is only one excuse to miss practice. Just one. Just one. Death in the family. And you died. That was it. Well, no excuses. There was you missed the 90 days, you're not in tax court. So now you're forcing your client to pay. Okay. The government has 60 days to send a response. However, if the government misses the 60 days, it's okay. Yeah, they're very liberal in allowing the government, if you could show that the 60 days, if they missed the 60 days to respond, if you could show that that prejudiced your case, that somehow it caused you to lose an important defense or evidence, maybe, but over 30 years practicing law, never saw it, never will. The government needs more time, the courts will always give it. Not for the taxpayer. You missed the 90 days, right? Okay. So that's point number one. The other point is what we were talking about, the 3-year statute of limitations. 3 years. I told you there are exceptions, but stay with the 3 years. My client comes to me and says, I'm getting a bill, an assessment from the IRS for a lot of money. I don't know why. You don't know why? Well, he said there was an audit. They examined my return. We didn't agree. So we didn't agree, but I never received the 90-day letter. If I never received the 90-day letter, then the clock to start your time to respond never begins, right? I mean, if they have to send a notice to you. That starts the 90-day clock. Does that make sense? Okay. He said, I never got the letter. I said, are you sure? Because they send a letter in our country, that notice is sent with our postal system. Works a little better than the one you have here, I might add. But you send it in a way that it's called certified mail return receipt requested. What does that mean? That there's special documents that you pay for when you send when the government sends a notice that proves two things: that you mailed it and that the party received it, because they have to sign a receipt. Every 90-day letter goes out that way. So I say to Calandra, what are you talking about? They must send it out. Because we did a little research, we found out that there was a 90-day letter, you missed the 90 days, and then they assessed and they're trying to collect tax. So I said, you say you never got the 90-day letter. Okay. We look into it, and we start the tax court case. Why? Because in the meantime, the statute of limitations had expired. If the 90-day letter stops the statute of limitations. So within 3 years, they must assess, they must give you a bill or send a 90-day letter. They never sent the 90-day letter, so my client never received it. Okay, that was his argument, that's what he's telling me. And they didn't send him a bill until 4 years later. So the statute of limitations was closed. It's a little confusing. Does it make sense? So if my client is telling me the truth, that he did not receive the 90-day letter, the government cannot collect this money. The statute of limitations would close. So the issue was just one issue. Did he receive the notice? It's the only issue. I subpoena from the government all the documents. Show me the paper. Show me what you have that proves that he received the letter. And oh, by the way, I said you sign a receipt. You don't have to. All the government has to prove is it delivered the document, not that you received. That's what you signed. As long as they deliver it to your house, you're in. Okay? So some people could refuse to sign the green. It's called the green card. You don't get to rely on that. So all the government has to prove is, hey, we mailed it. We can prove we mailed it, and the reason they like the receipt is that's proof that you received it. But they did not have. The government did not have any signed receipt. They had the paperwork that they mailed it, but they had no evidence that the document had been delivered or received. Okay. Before the hearing, so what's my evidence? I have two pieces of evidence. I have my client who says, I never got it. But I also have, for the judge, look at the paperwork. They mailed it. It could have got lost in the mail. We don't know what happened to it. We never got it. There's no signed receipt. There's no proof. It's now, let's say it's 5 years later, 6 years later. Before the hearing in the United States, you have to talk about, by the way, remember, this is my colossal failure. Just keep it in mind. Okay. In the United States, you have to tell who you're putting on the witness stand before the hearing. No surprises. So before the hearing, I say to you, who are your witnesses? Because I get an opportunity to talk to them before the hearing. Okay. That's how it works for the taxpayer. I get to court, and they bring some guy into court. I never saw him before. They sit him And the attorney now comes over to me and says, "Oh, Jim, by the way," his name was Perez, I think. "Mr. Perez is going to be testifying." "Oh, who's Mr. Perez?" He said, "He's the mailman." "The mailman? The mailman from what? From 5 years ago?" "Yes." "You're going to put the mailman on the witness?" And I want an adjournment. I want an opportunity to interview him. I want to hear what he's going to say. So I objected immediately. "Your Honor, we need an adjournment." I said, "They bring in a witness. It's a surprise witness. I haven't had an opportunity to question him, to hear what he's going to testify." The lawyer for the government says, "Your Honor, we just found him. We've been looking and looking and looking, and believe it or not, we just found him. And we tried to call Mr. Constantino over the weekend. We couldn't reach him. Who's in the office over, and you don't answer. We're closed over the week. We're in there. We don't answer the phone." So, judge said, "You know what? We're going to go ahead. But I'll tell you what, Mr. Constantino, I'm going to give you a lot of discretion. You can ask whatever you want, however much time you need." Going, "Your Honor, I need to be prepared. You're putting me in this box. I don't know what he's..." That guy got on the witness stand, and here's what he testified to. He said, "I remember bringing that envelope.
5 years later.
5 years later.
One envelope.
I remember bringing that envelope." He was sitting there. He said, "Have you been a mailman a long time?" 25 years. I know all of my people." "And you remember this envelope?" This is the government lawyer. See, he goes first, right? "Yes." And what did it look like?" "Well, it looked like this envelope." They had the envelope, but that's what it looked like. "And what do you remember?" "I remember, I remember it was cold." "Yeah, it was February, all right?" So I remember that. He said, "And I remember that I went there and I put it in his mailbox." That's what you recall? "Absolutely." "Are you 100% sure?" "100% sure. I wouldn't come and lie." This is what he's telling. Can you imagine, just quick aside, you're a postman. IRS shows up. They'll send 2 agents. They say, "We want to talk to you. We need you to..." What do can you imagine the pressure he must have felt? Okay, now I've had no opportunity to prepare, no opportunity to interview him. I got a guy sitting on the witness stand, remembering 5 years ago he delivered the envelope. So I start my cross-examination. I go, "Mr. Perez, let me make sure I understand this. You remembered 5 years ago..." Well, by the way, Anna Kirshner was with me. We had an associate. I sent her outside. We didn't have internet back then. I wanted to find out what the weather was that day. All right, you'll see why in a second. I said, "You remember delivering the envelope?" "Yes, sir." "Into the mailbox?" "Yes, sir." "What color was the mailbox?" I don't know if I remember. "You don't remember the color of the mailbox?" Your Honor, he's abusing the witness. Move along, Mr. Constantino. He testified. Okay. Here's the good part. I said, "Okay, you remember delivering that envelope?" "Yes." "You realize that if you remember delivering that envelope, if you delivered that envelope, my client's going to lose this case. You understand how important your testimony is. You understand how you have to tell the truth with complete certainty. Do you know that?" "Absolutely." "How many other envelopes did you bring that day?" "What do you mean?" "How many other envelopes did you put in to the mailbox? You brought my envelope. Was it 1 piece of mail, 2 pieces of mail, 5 pieces of mail? And by the way, what did they look like? White envelopes, green envelopes? How many envelopes? Was there any advertising? Was there a newspaper? Was there a folio? Can you tell me? What did the address say? Did it have his address, the wife's address? Did it say resident? What was it?" I had this guy by the throat, right? No. IRS attorney stands up and says, "Your Honor, that's irrelevant. The only thing that is the issue, it's always about the issue. The only issue in this case is, did he deliver the envelope?" I go, he goes, "You're right, Mr. Constantino, move on." "Where am I going to move on to? I have nowhere to go." I said, "Your Honor, it goes to credibility. It goes to believability. I'm not saying the man's lying, but can we at least get enough evidence, enough information in to prove that his recollection is correct? See the difference? Do you have anything further, Mr. Constantine? I have nothing. What am I going to do? I had nowhere to go. I asked him, I said, can you tell me what the weather is like? Objection. You're abusing, you're badgering the witness. So I'm asking him what the weather was. I think it was cold. It was, like I said, it was fine. Okay. Well, was it cloudy? Was it sunny? Was it snowing? Was there snow on the ground? Sometimes in February we have snow. I could ask none of those questions. We lost. So, you asked me about the biggest tragedy in my career. I was outraged by the decision. I was outraged because I'm telling you, this may be, you could tell me anything you want. There is no way that that man remembered what he delivered 5 years earlier on that day. No way.
Did you appeal?
And that is what, did I
Good
appeal?
question.
Excellent question. Excellent question. Let's talk about appeals for 2 seconds. In the United States, you only appeal the law. Every case has 2 aspects to it. It has the facts, and then the application of the law. The trial court, in the United States, a trial court is designed to determine the facts. Once the judge says, these are the facts of the case, you cannot appeal facts. You can appeal the law. If you say, okay, these are the facts of the case,